morning, everyone. I just want to check and make sure everybody can hear me. So if you could just put in the chat box if you can hear me, that would be great. Okay, great. Thanks. Sounds like everything's working fine on the audio end. Good morning, everyone. Thank you for attending this month's lay legal webinar on advanced family law. My name is Ginger Butcher. I'm the Director of Victim Services for ACESDV, and I'll be facilitating today's webinar. Just want to go over a couple of quick housekeeping items before we get started. If you have any questions as we're going through the presentation, please feel free to type them into the chat box on your screen. I'm going to hold off on asking the questions until the end of the presentation, but we will have time at the end to go through any of the questions. Also, sometime next week, I'll send out an email with a link to the recording of the webinar along with the presentation slides and information about certificates of completion for those of you who might need one. Our presenter today is Tom Alanji. I'm going to go ahead and hand this over to him at this time so he can introduce himself and start his presentation. So Tom, if you're on the line, go ahead and take it away. Okay. Okay, hold on everybody. Looks like we might have some technical difficulties. Okay, we're just trying to figure out how to, what's going on with, with Tom's audio. If you can just hold on for just a moment. I'm sorry about that.
Hello? Hello?
Hi, Tom, is that you? We can hear you now.
Hello? You guys hear me okay?
Yes,
Hello?
we can hear you now.
Okay. All right, great. Yeah, it's not letting me type in the boxes though. I can't advance the slides, and it's not letting me type into the chat window, the chat field. It's like
Okay.
My mouse is not even letting me. I think you can hear me now. I can hear you guys great, but I'm not. It's not responding. It's got me logged in, and I can see people typing. Christina Ashelford, Carmen Raz, Alice are all typing things. I can see other people typing things to me, but it's not letting me do anything.
Huh, that's interesting. Okay. And you're not able to advance the slides from your end?
No, and that's all that would really matter, obviously, because I could skip all the rest. I don't have to type chat stuff, and if you can hear me, then who cares whether I can hear anyone else, right? As long as I can read the chat and talk, then I'm okay. Oh, here, now you're sending me an invitation to chat. That's nice. Okay, here you go.
Oh, okay, yeah.
I accept this invitation. No, it's not even. It's not letting me click yes or no either. It's as if my mouse had just all of a sudden turned off.
That's interesting. Okay, let me.
But it's not the mouse because I can navigate to other windows in my browser.
Okay, let me just try with your settings really quick. And
sure.
Try and redo this.
Yeah, no problem. We'll figure it out.
Okay, can you try again and see if it'll let you advance the slides?
No, in fact, the dialog box where it says that you invited me to chat, do I accept that invitation? That's the only window that's up now. The rest is all grayed out in the background, and it's not letting me click yes or no. So not only can I not click anything else on the page, I can't even close that dialog box to get back to the screen I had before. I wonder if I should just go ahead and close this out and just try to log in again, maybe?
I think that's probably a good idea.
Okay, then I'm going to close this window. So I think it'll keep me on the phone with you, but I'm going to lose the whatever you did on the website. So hang on.
Okay. Sorry, everybody. Hang tight.
So I'm up. And yesterday, the dry run, it worked great. So I'm sure it'll be easy. Let me try going here. Okay. That's good. Okay. You will use this link for our test run today and into the webinar tomorrow morning. Okay, so let's try again. Okay, and now it's saying registration required, which I did. But then it says here, if you've already registered and can't locate your registration confirmation email, click here. And I'd save all the emails. Okay, so confirmation of registration. Okay, so I'll click join again.
All right.
It's checking, connecting, checking, connecting, initializing. Okay, I'm back on the screen.
Okay.
And now it's letting me type.
You can type. Okay, give me just a moment. I will make you a presenter again.
Yeah.
Okay. Now, are you able to navigate?
Yes, I am.
Perfect. Thank you so much. Thank you, everyone, for your
patience. All right, great.
All right, I'll let you take away.
Yeah. Well, good morning, everyone. My name is Thomas Alonji, and I'm a private practitioner here in the Valley. And I've always had the honor and privilege of working with the coalition to present, these webinars for lay legal advocacy. And I find that they're really helpful because it's one of those rare moments where we can all get together and kind of come from different walks of life. Typically, we have a selection of attorneys on the phone, especially those who work in nonprofits. But I know also we've had some private attorneys who have checked in from time to time, and that's really helpful too because with members of the private bar, these are folks who are in family court a lot of times representing both people accused of domestic violence and people who have suffered its effects. So always look forward to outreach opportunities and of course the opportunity to meet with advocates who are getting ready to jump into the trenches and help out folks who are going into shelter, who maybe have to navigate family court, and I'm sure that's probably the bulk of the people that I have on the phone today. So what I'm going to do is, I know this is part of a greater training, and so I always make this disclaimer before I get too far into it. And that is, I know right out of the gate that there are probably going to be people in our gathering today who may have heard me talk before, and there will also be people who have already received a dosage of DV 101, for lack of a better phrase. So if you had, every year I change some of the slides. Some of them will look the same. So if you suffered through my webinar last October, I make no apologies. You're back, and I didn't make you do it. But there's going to be, toward the end of the slideshow, at least 5 or 6 slides relevant to new case law that has come out since October. And also, I throw in extra new stuff as we go through all the slides. So hopefully this will still be a good experience for you. And if you are already well familiar with domestic violence, it is entirely possible that a great many of you know more about domestic violence than I do, and you're just here to learn more about how family court in particular works. So I want you to know that I'm mindful of that as well. So without further ado, I'm not going to talk a whole lot about my background because I'm going to include my CV with some of the written materials that will accompany the email that goes out to you afterward. And would rather not waste your time talking about myself. But the short version is I've been practicing for about 28 years. Started out as a prosecutor doing domestic violence prosecutions, and also crimes involving vulnerable victims in general, child abuse, neglect, that sort of thing. And I have also, and so I started out as a criminal court lawyer, and then came to the Valley in 2004, and the bulk of my practice since then has been family law. So I'll leave it at that, and then if you want to know more about my background or get to know me or share copies sometime and talk about this stuff, all my contact information will be on the last slide. And of course, Ginger and the other folks at the Coalition, they know how to find me too. So I want to start with the business of some of the dilemmas that survivors face when they are confronted with the decision of whether to leave the relationship in the first place. And anyone who has spent more than 5 minutes reading a book about domestic violence probably already understands that there are very few good choices, if any. And these first 3 slides, in many ways, are perhaps the most important 3 slides in the entire PowerPoint presentation, because I think that they illustrate in a single blow just exactly how impossible the situation is when a domestic violence victim is debating, do I go, do I hold out a little bit longer, do I follow through with this divorce? And I'm offering this to you so that if you are ever confronted by a member of the public, if you're doing legislative advocacy, if a batterer's lawyer is sneering at you because he or she just doesn't understand why the victim couldn't have done 1, 2, 3, 4, 5. These 3 slides are a great place to start. So choice number 1, she could stay and work things out, and millions of domestic violence survivors initially choose this option all the time, and there's a reason why survivors on average reconcile with their abusers, good 7 or 8 times before they leave, because there are all kinds of psychological, financial, safety reasons why a survivor might think, I'm going to tough this out a little bit longer. And a lot of women will say, well, I stayed in a relationship with the kids, and it was only when the violence extended to the children that I thought, I'm done. But this first slide, this is a choice that a lot of survivors go with for years or even decades, long after the children are out of the house, because for any reason, cultural, psychological, safety, they just aren't prepared to leave. So that's choice number 1. you can stay and work things out. Of course, the problem with doing that is if you stay in the home and DCS is involved, you face the prospect, the threat of losing your children on so-called failure to protect grounds. And with DCS, I will hand out both kudos and some fair criticism. These are good people. They went into this field for a good reason. They wanted to help. They love kids. They're educated, and they want to go out and make a difference. And I think, even the ones who are hard on survivors and impatient, if you will, I think their heart's in the right place. They want the kids to be protected. But the criticism comes in this form, and that is that a lot of them, because they are inexperienced, they may be fresh out of college, they may lack life experience, they may not have had children of their own, they may not have gone through domestic violence dynamics of their own or known someone who did. And so, with a given worker, you may have a certain amount of impatience, intolerance, and at some point, especially if they don't have a lot of training or experience in the field, there will be that inevitable conversation where the worker says to the survivor, if you don't keep the children away from him, we're going to take the kids away from you. And it's a hot button legal issue. There's a limited amount of case law, and if you want to have that cup of coffee with you sometime, I'll talk about that case law. But there's some interesting case law out there about the extent to which the survivor has the right to not have children taken away from her simply because she's the survivor. But in general, it's a threat that should be taken seriously. The problem is DCS will very rarely put that in writing. And I've gone around and around with them on this for years, because they'll have that conversation verbally in the kitchen with the survivor, and then the victim's like, okay, well, I'll keep the kids away from him, and I'll move out and I'll hide and I'll get a protective order. And then right down the street, you've got a family court judge and a family court lawyer for the abuser who is jumping all over the victim because she's a quote-unquote alienator. She doesn't respect father's rights. She's not a team player and can't be trusted to co-parent. And by golly, judge, we should just take the kids away from mom because she doesn't respect that 50-50 we got going on in Arizona right now. And so it's a dangerous decision. To stay in the home is not just a dangerous decision physically, and of course safety is the primary consideration. It's a dangerous decision litigation-wise, because ultimately when she does reach that point where she feels confident enough to step out of the house and build a life of her own, they're going to come back and say, well, gee, honey, if it was such a big deal, why didn't you pull out 5 years ago? Where are your police reports? Where's your protective order? Where are the photographs? Where's all that? And so you get a lot of, and some of those questions are legitimate questions that an attorney has to ask, but there's also, across the bar and across the board, an element of disdain, uninformed disdain that goes beyond simply asking fair questions that even I would ask if I was in that situation and I had to represent someone who's going through this. There's an element of nastiness, if you will, that a client faces if she chooses this curtain, number one. Unfortunately, they are repercussions that don't realize themselves, until down the road. So it's hard to visualize, hard to picture them. Most women, when they go back into the relationship or reconcile, they aren't thinking about things that lawyer Tom's going to say 3 years later. They're thinking about, hey, how do I make this family work? So if you're in a position where you are talking to a survivor who is really considering going back into the home, giving it a shot again, number one, it's important not to ridicule her for that, of course. Number two, though, if the opportunity presents itself, with a tremendous amount of kindness and support, make sure that she understands that there may be a legal repercussion down the road, that if she makes this decision to go back. And then, addressing the safety issue first. But if she's wondering, or if the conversation comes up about how is this going to affect me later, you might want to, let her know that, not only might DCS give her a hard time, right or wrong, but also that, she may face some flack in family court. So that's part one of what I call the trilemma. Number two, the victim's next choice is she can take the kids and run. Well, the upside there is the kids are temporarily safe. She disappears into the lace work and doesn't come out. For the moment, she's done what she could to protect the kids, but if you spent more than a minute in family court, then you already know that, if a woman takes, some kids and disappears, they're going to slap that abductor label on her, before she can blink. Now she's a kidnapper. Now she's, a criminal. And this even happens with women who don't necessarily disappear and can't be found by anyone. This allegation, this accusation, even happens to women who do it by the book and don't disappear. They simply keep their address confidential and try to work the court process. I've had a couple of clients who were consulting with me before the case was even filed. So it wasn't as if there was some court order restricting her to stay in Arizona. It wasn't as if the relocation law even applied to her. This was a woman who was simply wanting to, eventually relocate to Colorado from Arizona, and she was getting ready to file for divorce. So I hand walked her through the whole process. We did the petition. She had no place to go, but she had parents living in Colorado. So she went up there with the kids and made arrangements to find her own place. We filed an Arizona petition, so the Arizona judge would not think that we were trying to, reject her authority. And we even made it a point to say in our dissolution petition that we respected Arizona's right to make decisions about the case. We respected the right that father had an interest in the children. We were prepared to honor any long-distance parenting plan that the court might want, and even return with the kids to Arizona if that's what the judge wanted us to do. So we could not have made our level of willing compliance any clearer, and yet still, not only did the father's lawyer start waving around the abduction flag, but the judge herself, made the comment, well, wife took off with the kids without permission. And so that is a disturbing attitude that your clients need to be aware of, that even when they don't break any laws, even when they don't break any rules, or orders, that they're still going to be subject to criticism, and they should be prepared to face that. So that's impossible choice number two. And then, impossible choice number three is, well, she could just take off on her own and leave the kids behind. And I don't think you're going to find too many conscientious moms, or dads, who are going to just take off from a violent relationship and leave the kids behind to fend for themselves. I'm sure anecdotally you might come across cases where the violence is so severe and the situation with the children and the abuser is so complex or unusual that the victim's like, I've got to get out of here or he's going to kill me. I know that happens, but in general, you will be hard-pressed to find a domestic violence survivor who would even contemplate leaving behind her children, especially if violence against the children is what triggered her to leave in the first place. So, I throw out this impossible choice number three because logically it is an option, but the reality is you will rarely see this ever happen. But the point of these three slides, obviously, is to say right out of the gate that I am mindful of the fact that there is no good choice when kids are involved, and it's one of those damned if I do and damned if I don't, and it's not my goal to put you into abject despair 20 minutes into the presentation, but just to first reassure you that I understand that that's out there, but two, to make sure that you understand that those are the choices before a survivor plunges into family court. Those are the cards that she has to play with. And so it's important, I think, at every possible turn for her to educate the people around her. If it means, if she's all by herself and she has no lawyer and the opposing side is getting on her case about her bad decision, there's nothing wrong with writing back politely and saying, look, what is it that you wanted me to do? Here were my 3 choices. 1, 2, 3. If I'd done this, you guys would be doing this. If I had tried number 2, you'd all be saying this and you'd be getting arrest warrants for me. And if I had taken off with the kids, you know darn well that you'd be in court right now ridiculing me for being an unfit mom and for abandoning the children, and you'd be demanding custody for that reason. So, before you criticize me too much, I'd really like to hear you say what you think I should have done, to please you and your client. There are polite ways you can say that, and it has the virtue of not only, maybe, you never know, you may be dealing with an opposing lawyer who would like to do the right thing but has never learned about this stuff. The family court bar is a curious collection of lawyers, spanning, all kinds of demographics. But a lot of them, they just never heard me better. They pick up a bar journal or they pick up, some court decisions. It's a very insulated existence. And it is hard to get, it's hard to get anyone to break a habit, but it's especially hard, I think, with attorneys, because we are a profession that has been trained from day one of law school to put aside emotion, empathy, sympathy, feelings, compassion. I know law professors would be probably annoyed with me for trying to make the whole process sound heartless, but the reality is that emotion is usually the enemy of the law. People make bad decisions when they're emotional, when they're impaired by feelings of hurt or loss or fear. They often make really bad decisions. And so the legal profession in general doesn't have a lot of patience for emotion and all the things that make domestic violence so difficult to deal with. And so when they encounter a domestic violence case, they kind of run back to their default setting, which is, hey, let's think this logically. If you were really a victim, you wouldn't have stayed. Since you did stay, logically, the violence must not have happened, or it must not have been so bad, because logically, if you called the police, surely the police would have done something. And logically, if the police showed up and there were injuries, then surely the police would have done the right thing and arrested the right people. And because they didn't, then logically, something's wrong with your story. And it's a very comfortable, cozy little cocoon that lawyers love to hide in because, in their view, most domestic violence allegations are false. In their view, and this is because look who's getting all the airtime. Abusers tend to have more financial resources, so they are more likely to be able to afford private lawyers. And so, the private bar as a whole, I don't want to sell out individuals who might be really smart, really educated, really good DV advocates, but as a whole across the bar, you're dealing with people who really haven't made learning about domestic violence a priority and who might never once have even read a single article about it, or even worse, read an article about it, but it was a really dumb article that didn't know what it was talking about. And so if you are helping a woman who's going through this situation and she's getting these nasty grams, these letters from the opposing lawyer, and the opposing lawyer is mocking her for her decision-making process while the domestic violence was going on, you might want to toss these 3 choices, back and say, okay, here it is. So next step is, domestic violence screening. I had to put a photo of a really gross insect at some point in this slide because I'm a guy and it's a guy thing, I guess. So there's your really gross, disgusting insect, and you can knock me down 1 point on my rating sheet when this is all over. But screen the case. You never know when you're getting a domestic violence survivor. Now, because of the role that you're going to be filling, chances are you're only meeting this person because domestic violence has now bubbled to the surface. So this particular slide is aimed at my colleagues who may meet, a client for the first time who never says a word about domestic violence, who is presenting a property dispute or, a civil issue regarding, land boundaries or contracts or something like that. But you never know when domestic violence might be influencing the dynamics of what is going on, even though the issue at stake on its face doesn't seem to be really related to intimate partner violence. So I guess my suggestion in your situation is if you meet someone, a client, who reports that there was family violence in the home, do not assume from that first interview, or even the second, or the third, or the fourth, that she has told you everything. And this is something that I encounter as a male attorney because, let's face it, it's hard enough for a DV survivor to even confide in their family and friends. An even more difficult task to go confide in a female attorney or a judge or an advocate, but to then have to take the next step and sit down with some guy who's a total stranger who, for all she knows, is just as much a batterer as her husband or boyfriend, and to open up, well, that's not going to happen. In fact, I'm surprised it happens as much as it does when I meet with my clients. So the screening is important because you don't know what she's left out. She might even not remember some of the things that have happened when you first talked to her in that opening appointment. And, these next slides are all taken from a written screening tool that I use for my clients, which I can give you as part of the written materials. They're charts, and each chart documents a different type of controlling or abusive behavior. And every woman I've ever handed this to, I've been using it now for about a decade. Actually, it's been about 13 years now. From 2004 till now, and every woman I've ever given this to has invariably come back to me at the next appointment and told me, Tom, I forgot how much stuff this guy had done to me before, until I saw this questionnaire and I had to start regurgitating it all in this question. So you're going to unearth a lot of stuff, and it makes sense because, what survivor is going to want to remember that stuff? Most of them dedicate themselves to trying to put it in the past because they're trying to make the relationship work, and they're remembering the best about an abuser and the better times. So, it's actually a rare survivor who even writes this stuff down in a journal. So do the screening. Even if you think you got it all, do the screening. And so, there's the different behaviors. You've got, threatening behaviors, which can be, threats to take or harm the children, threats to commit suicide, threats to harm the victim herself, threats to harm friends or pets. I'm skipping through here. There we go. So you might also have confining behaviors, where the suspect, the offender, forbids the victim to leave her room or her car or the house. He might hold her down on a table, floor, or bed. He might lock her in the worst cases, actually lock her in a closet or in a room or just in the house itself. A lot of guys will restrain the victim by holding her against the wall by her wrist, or just physically block her from leaving the room until he, quote unquote, makes his point and wants to be heard. But confining behaviors, they're in that periphery of domestic violence acts that are difficult to explain to a judge, and you have to convince the court of their severity, but they're a favorite tactic by the abusers themselves because the message is sent to the survivor that A, she has no autonomy, B, he'll dictate where she can go, she doesn't make that decision for herself. And so it can be difficult to translate that attitude into a family court argument that will show the judge that maybe co-parenting isn't the best idea in the world. And I'll talk more about that in a second. So you've got confining behaviors, and then you have your outright, assaultive behaviors, and those are the ones that the law tends to look for the most. You've got, damaging property during arguments. A lot of guys love to slug that hole in the wall right next to the victim's head to make a point. In fact, I'll do a little aside on this one. I was at a really big annual family law conference, continuing legal education conference, and I won't say the year or the location or the month because I want to protect the privacy of some people, but it's one of the better known conferences every year. And I'm in there, this was a few years ago, and there was a judge on the panel. And the judge, I think he meant well, but he got up there and was talking about this issue of punching holes in the wall. And he was applauding the fact that it was just the wall, and actually made the statement, geez, maybe the guy should be complimented because he only hit the wall and showed the restraint necessary to not actually hit her. And I'm in the back of the room and just appalled. But you'll hear this a lot from people. You'll hear lawyers make this excuse, or the offenders themselves, because they're always looking for excuses. This idea, this notion that isn't he a real stand-up guy because he quote unquote restrained himself. She provoked him and pushed his buttons, and what a swell person because he was able to control himself and only hit the wall. Well, that's a lot of nonsense. The reason why he punches the hole in the wall next to her head is to convey the message to her that your head could be next if you don't do what I expect you to do. If you don't back down and back off whatever argument you're making and recognize that whatever point I'm making, that's the one you need to pay attention to. So that stuff is a problem. And you will encounter that mindset all the time. So going through the rest of the assaultive behaviors, you've got punching or kicking, shoving, slapping, pulling hair, hurting the animals as a way of conveying third-party threat to the victim herself, throwing objects at the victim, burning her. Strangulation is a huge one and a major lethality factor, and then insisting on sex when the victim refuses. That's also known as rape. The reason why I put it the way I did was because the survivors themselves don't like the R word, especially if it was a marriage. They're very uncomfortable with it, especially women. And I'm 52 years old. Women in my generation, but even some of the younger ones, they were raised to believe that sex was prerogative of their husbands and that they were expected to comply. And so it could possibly be rape because, well, I married him and that comes with the turf. And so that really can't be rape. But if you turn around and just say, okay, did he ever insist on sex with you when you didn't want to do it or told him no? They'll say, oh, well, yeah, that happened all the time, which is rape. Okay, so again, words can be really powerful, inflammatory devices. They can be used to make a really strong point in court. But if you use them haphazardly, you might deny yourself important information that you might have gotten if you had couched your words a little bit differently. Never forget, even if she likes you and seems to enjoy talking to you, never forget that she may not be comfortable with this idea of just spilling everything that happened or characterizing it the way you have been taught to characterize it. I'm a former sex crimes prosecutor. To me, sexual assault, mister, stop making excuses about it. That's a class 2 felony. But the problem is, you've been educated on this stuff before you ever walked into this webinar. You're getting more here. You're going to get more tomorrow. A lot of survivors don't have that level of education that you've got, so you have to maybe ask questions in a way to draw out information without using labels that we would use, you and I, in a conversation at the coalition or in court. So I hope that helps. And then you have the issue of financial control, of course. That tends to be underestimated, and yet it may be one of the biggest reasons why survivors stay in a relationship, because they have no economic options when they get out the door. And it's especially a problem when the victim's own family is supporting the abuser. And that can be a really isolating experience. Looks like I've got a message here. Someone saying, "Can you back away from the microphone?" It's a corded microphone on my phones here. I can try. Is that any better? Someone say yes or no. Type yes or no. I'll try to hold this thing. Yeah. Oh, great. Okay. Yes. Okay. Cool. All right. Boy, my arm's going to get tired. Okay, that's all right though. I'll just suck it up. So the next type of behavior is lifeline disruption, isolation. You'll get the guys who will seize or confiscate the victim's phone, erase or read her private email, eavesdrop on her, control her use of the internet, or just insist on supervising when she is on the web. They'll stand over her shoulder and make sure that she's not going anywhere or talking to someone that might be a support network. And sometimes, and this was more before the age of cell phones, but even now, you'll get offenders who will actually yank a phone cord out of the wall to prevent the survivor from calling someone, including 911. And then your isolation tactics. And this can take several forms: ridiculing or publicly embarrassing the survivor, dictating who her friends or outings are going to be, cutting her off from her own family, lying about the victim or complaining about the victim when speaking to her family or friends as a way of maybe having them think twice about whether she's the kind of person they want to keep in their lives. It can be harassing her at work to the point where her own employer says, "If you don't make them go away, we're going to fire you." Threatening to report her to immigration authorities, especially in today's political climate. These are all really effective weapons for an abuser to keep a survivor in line. Now, this is a family court seminar, and so before we take about a 5-minute break here, and this would be probably a good time to do it, I want to throw out the problem with how do you convey some of these behaviors into a family court argument that might get you decision-making or a greater share of the parenting time. So before we take that 5-minute break, I'm going to go there. The only other behavior, if you will, controlling behavior, is this business of keeping the victim from having her own career or hindering her higher education. So it's not just about, saying, "Oh, honey, you make the meals, you vacuum the floor." I mean, that's a little bit archaic too, but you have the problem of, when the survivor says, "Well, I'd like to go apply for this job. I think it could really help our family income, and this would help me get, some job skills." A lot of times you'll get an abuser who will say, "No way, man, what? I'm not good enough. I can't provide for the family. You don't need to be working outside the home. That's me. That's my job." And it's a twofold response, because on the one hand, the batterer is like, "Well, she's questioning my ability to be a breadwinner and, demeaning my manhood." But then beyond that, there's the latent threat to his control over the relationship, because, of course, the more she develops her job skills, the more likely she will be able to flee him if things get bad. And that takes me to the last part before our break, and that's this issue of how do we define domestic violence? And you got to be careful about this, because domestic violence intervention, when it's done right, attracts professionals from different walks of life. You'll have your social workers who maybe work for DCS. You'll have your lay legal advocates who do what you do. You may have employees who work at shelters or the coalition or other nonprofits. You'll have attorneys who have to go into court and represent domestic violence survivors using the laws and the procedural rules that everyone has to follow in court. And the problem is the definitions are different, even for a phrase as seemingly simple as domestic violence. The sociological definition for domestic violence is the better one, and I just threw it up there on the screen for you. It's the definition on the right, and ironically, it's a definition that appears in a legal publication. The NCJFCJ is an association of family and juvenile court judges across the country, and they have a beautiful manual, a book, on how to adjudicate custody cases that include domestic violence. So you would think just by looking at that one book that, oh, well, great, the judges get it. Look at this wonderful NCJFCJ thing. Of course the judges are on board. What have we got to worry about? Well, the problem is, membership in the NCJFCJ is not mandatory, and there's no assurance that even the people who belong to the organization would necessarily read this manual or memorize it. And even if they did read it or try hard to memorize it, life gets in the way. You get on the bench, you forget stuff. You don't necessarily retain information that you processed, or you may be confronted with a case on a bad day where you just forget the lessons that you learned. But here's this wonderfully broad sociological definition of domestic violence on the right, the white side of this slide. And it's a good one. I think it's the one that most of the advocates that I've met at the coalition and elsewhere would endorse, because it's comprehensive. It includes all the behaviors that we just got done talking about on all those slides. And I really like how they say that the pattern of behaviors is neither impulsive nor out of control, but is purposeful and instrumental to gain compliance from the victim. The problem is that's not the definition under the Arizona statute. And there are lots of reasons why this is true. I think in part, there are just people who are uncomfortable with the idea of letting someone lose custody because of psychological abuse. It's a really big deal. I was on a legislative work group in 2012, back when they were debating the change to that custody law. And what never made it into the statute was a bunch of language that my colleagues and I at CLS and the coalition put together that would have made coercive control a specific consideration for the family court before deciding who gets custody. It would have required the judge to go through all those behaviors that I just rattled off to see if maybe there was an underlying element of controlling abusive behavior so bad that it would actually jeopardize the emotional or physical health of the children. And I have to tell you, we encountered incredible resistance from all kinds of people. Fathers' rights advocates hated it because a lot of their ranks are permeated with abusers. A lot of people felt like it was an anti-male feminist agenda designed to make men look bad, even though the language of the proposed bill was gender neutral. There were a lot of judges who I think were dreading the idea that it would open the floodgates to litigation, and they already have crushing caseloads. And there were a lot of lawyers who believe, it's bad enough we have all these sneaky, manipulative women making up DV allegations to quote unquote game the system. Why would we ever want to give them an extra tool to make it even easier to deprive, a good dad of custody? And then there were just a lot of people who made really snarky, smart aleck comments about, oh, you just want to legislate bad behavior. You want to punish bad behavior. And all of those responses were difficult to swallow because it really showed that they just don't get it. That there's a difference between two otherwise, healthy, normal people who maybe just don't belong together. They kind of snipe at each other, that they have disagreements and fights, but without that element of control, without that element of you belong to me, without that expectation that I will always get my way because I'm the one in charge and you don't count as an equal. And then, of course, that really psychologically destructive behavior that goes on for decades where, a survivor is told, you're ugly, you're fat, you're stupid, you don't count for anything, you will never amount to anything, no man would ever take you if I didn't take you, no way are you going out for the friend tonight, you're staying here at the house until you learn how to cook that dinner right. This is not normal behavior. These are not behaviors that are to be found in a relationship with two co-equals who just really don't belong together. There's something else going on that needs to be addressed. And the family court system just isn't ready for this. I'll just put it bluntly. You are going to encounter this problem all the time. That you will have, really smart, good women working at the shelters who teach these survivors this is what domestic violence is, and they're absolutely right. But going in the court and saying, well, he exerted power and control over me, give me custody, that goes nowhere. In fact, that's a real problem because a lot of times people who don't have lawyers are so nervous, they're scared, so they come into court and they throw labels out. Oh, he's a narcissist. Oh, he exerts power and control. He's a psychopath. Those labels don't help at all. In some ways, they make it worse because the judge starts to think, okay, why is he a sociopath? How did he exert power and control? How was he abusive? And then it becomes very difficult for the survivor to articulate that because it's more difficult. It's more difficult to give raw data than it is just to say, hey, here are the broad stroke issues. And so if you have a case that's heavy on psychological abuse, and there isn't much, if any, evidence of physical violence the way the Arizona statute would tackle it, you're going to have to think of other honest, accurate ways of explaining to the judge why joint decision-making is not going to work, why an equal parenting time plan would be bad for the kids. So you look at that definition on the left, on the black side of the slide, and it gives the statutory definition. You will see that it's all related to physical violence or the threat of physical violence. None of that other stuff is in there. And so more recently, in the last couple of years, what I've started to do is, instead of trying to convince the judge that psychological abuse is domestic violence, which it is, I mean, who are we kidding? Of course it's domestic violence. But instead of trying to do that, I have left the domestic violence statute alone. And instead, I have gone to the section of the statute that talks about the feasibility of joint decision-making. And it's not in the slide, but if you go, and I'll give you the statute number if you want to whip out your pencils and paper. But if you look at ARS 25-403.01, subsection capital B, B as in boy, okay, you'll see 4 different things that the court must consider when deciding who should be making decisions for the children. And those 4 things include, number 1, an agreement or lack of agreement between the parties. Number 2, whether a parent's lack of agreement is unreasonable or influenced by an issue not related to the child's best interest. Number 3, past, present, and future abilities of the parents to cooperate in decision-making about the child. And then number 4, whether joint decision-making is even logistically possible. And these days with the internet and Skype and all that, it's really hard to make an argument that joint decision-making can't work even with parents who live in different states. But you notice that number 3 that I just read out, the ability of the parents to co-parent. I've been taking controlling behavior, text messages, disdainful emails, voice recordings where he's screaming at her, telling her how stupid she is. I've been taking that data and I've been funneling it into that statute instead of the domestic violence statute. I think it's a more, until the Arizona legislature figures things out and recognizes domestic violence for what it is, I think the approach I just described for you is probably the more intellectually honest approach, and more importantly, probably the more effective approach, because you're not trying to cram behavior into the definition of domestic violence in court when the court definition of domestic violence clearly doesn't allow for it. I think it makes more sense to say, Your Honor, here are the acts of domestic violence. There was a push here, a shove here, a punch here. The police were called out on this day. He got arrested. He got diversion. We're not happy about it, but clearly it shows there was an act of domestic violence. But oh, by the way, over here, exhibits 12 through 368 are examples of where his behavior was so beyond the pale, so vile, so despicable, that no reasonable person could look at those communications and conclude that it was just an example of two disagreeable people who need to get divorced, that there's something way worse going on. And you got to be careful with that, because the family courts are not going to be patient with a whole, the 500 pages of text messages where the two are just sniping at each other. Don't do that. And if you got a client who's proposing to bring in 500 pages of sniping text messages back and forth, tell her don't do that, because they're not. That will just really irritate the courts and hurt her case. But if she's got communications where he is saying clearly vile, awful things or really controlling behaviors, and a lot of these guys, they're dumb enough to do it. They'll actually say it. And I think their arrogance gets in the way, because they're so used to getting away with that stuff, they start to think that they'll never be held accountable for it. So I'm not saying you'll always get that treasure trove of data in every single case, but I bet you'll get it more than you thought you would. And I think that's the way to tackle that. So what I'm going to do is I'm going to take a 5-minute break, so you can have a 5-minute break, and then relax, have some coffee. If you want to, I think Ginger has a method already set up for taking questions, because I'm going to stop at about, let's say about 10:50. We're actually more than halfway through, because there's some slides I can skip or go through quickly. So I'll try to set aside a good 5-10 minutes for questions at the end. And I'm willing to go past 11 o'clock if the program will let me do that, but that's neither here nor there. So go ahead and take just a couple minutes, and then we'll come right back on the phone, okay? Okay, I think that they start again. Can everyone hear me? Oh, good. At least Donna can hear me. And is my voice still very muffled, or are we doing okay? Okay, good. All right, looks like it's okay. All righty. Well, let's go through the home stretch, and then we'll finish this up. That's just iPad art. I was having fun, so I threw it in there to look fancy. Just skip that slide. Okay. The next slide, I put these visuals in here in part because I hate to bore you all with bullet points and just read to you, but also because I think sometimes a picture speaks 1,000 words. And that's this business of people's expectations of victim behavior. I almost hate getting into this too much because our society already talks way too much about supposed problems with the victim. Why does she do this? Why doesn't she do this? How come she did that? Instead of focusing on the batterers themselves and asking, what's your problem? Okay, but I think these next two slides are going to be important because on your darker days, when you're tired, and you're going to be tired, you're going to get worn down. This is hard work. It really drains you. One of the best advice I'll ever give you as a friend is to make sure you establish, personal boundaries and keep some quiet time to yourself and really stay on guard against things like, vicarious trauma. And the reason I say that here is because when you're working with survivors, and let's say you're having a low energy day, and the survivor comes in and she's having a tough day too, and she's lamenting the fact that she ever left the home. Why did she do that? Why was she so stupid? She was better off when she was with him. These are conversations you're going to have, and you will be tested that way because if you're having a bad, low energy day, you might think to yourself, oh my gosh, I cannot even believe she is talking like this after all the stuff we just covered last week. What is the deal? I thought she was getting better. I thought she was making progress, and now here she is talking about how, he wasn't so bad. And I think part of the problem with that is you're having a bad, low energy day, but part of it is because we tend to picture, all of us in this society, we tend to picture the victim's recovery, her escape from a relationship, surviving all that horribleness, taking these small steps toward building independence. We tend to look at that as being a straight line on a graph. And that's why you have that slide in front of you, because it's a really nice straight line showing upward mobility. Look at her go. She gets out of the house. Now she's wet and she got a minimum wage job, and it is only minimum wage, but hey, it's the first job that she's had in 10 years, and that's a big step, and it is. She just signed up for community college, or she's going back to get her bachelor's degree at university, whatever. These are all steps to be celebrated, but don't make the mistake of thinking that she still doesn't have her bad days. And so and you have to be ready for that. This happens in litigation all the time. Any prosecutor could tell you this, where they meet the victim on day one and she's really gung-ho. She's feeling bold and proud that she's finally sticking up for herself. And then the reality of what's going to happen next starts to devour her. She's going to have to testify against him. He's just got released on bail, and now he's threatening to come back to the house. Her own kids are saying, where's Dad? How come you did this to Dad? Daddy says that you're breaking up the family, and you called the police, and I thought you loved Dad, and how come you're making this family worse? It all starts to pile on. And so I would recommend that you look at survivor response kind of like that, like a heart graph or a stock market, not like a straight, continuous, gradual recovery. You will note that the general direction is up, and that's something we all push for, of course, because We want her to get out. We want her to build independence and move on. But, you know, it's not going to be smooth. And if your low energy day happens to match her bad day, there are going to be days that you feel like you just don't make a difference. And don't fall for that. You do. She may not be able to say it that day. She might not be able to say it to you any day. But she knows that you're there and you are making a difference. So at the risk of sounding like we're all standing around a campfire and singing, I'm telling you this not just for encouragement, but also so that you understand that this will also happen in court. She will have a really bad day in court. You know, maybe the judge doesn't seem to be too appreciative of her ordeal. Maybe the opposing side said something really awful and snarky about what happened, and so she starts to feel like, you know, why did I even file these papers? It's all wrong. This is all for nothing. I'm getting out of here. Try to remember that she's going through this up and down fluctuation, and try to help her understand that she's going through that fluctuation. It's a really candid conversation that I try to have with my clients on the very first or second day, when they're at their best, to tell them, hey, I love that you're really energetic now, but I want you to know in advance that there'll be days when you're not. You're going to feel like, what the heck am I doing? And it's to the best of your ability. On those days, I want you to just take a deep breath, resign yourself to the fact that you are going to feel like this today. That's what today's going to be. It's going to be a bad day. And look in the mirror and say, okay, I knew this was coming. This is going to be a not such a great day, but I'm going to do what I can to try to make it better. And if it doesn't get better, I will at least make a commitment not to do anything rash, say anything rash, or commit to anything, especially in my family court paperwork, the things that I said when I was in a bad frame of mind. Because this is the kind of thing that'll come back and snap at survivors later. They are feeling down, so they go in, they say things in their documents, and then they look back a week later and like, what the heck was I thinking? Why on earth did I say that? And it's because they're going through emotional upheaval. So try to bear that in mind. And hand in hand with that is this business of impaired judgment. Even in a case where there is no domestic violence whatsoever, judgment is impaired. There's no way to get around it. Divorce is consistently identified as one of the top 1, 2, or 3 stressors in our society. It contributes to heart attacks, suicides, drug addiction, alcohol abuse. It's not a happy time. Even in the most amicable divorces, it's tremendous stress. And so what's happening is, in addition to all the dynamics that come with your line of work, you are also dealing with someone who's just not going to make good decisions in general. And it's kind of sad, but also, at least when the case ends up well, it's also kind of cute when you see a survivor a couple of years later and they're totally different people. And they kind of look back and they're marveling at the fact, like, why on earth, I can't believe I actually did 1, 2, 3, 4, 5. And it's not because they were dumb, it's because they were impaired. They ought to have a law for driving while divorced instead of under the influence of alcohol, because it just affects how you evaluate every piece of information that comes across your table. And so what's going to happen here is, now take that normal impairment and blend it in with domestic violence. You're going to see a couple of things happen all the time. And every survivor handles this a different way. But they will have a great deal of difficulty finding that happy medium. If you can picture like a triangle, that you're on the trying to stay on the point, the peak of the triangle without falling off either end can be difficult to do. Or if you're a sports fan, you like baseball. They always say when you're trying to hit a baseball, there's that certain part of the bat that you'll get a really good hit. But if you hit the ball anywhere else, the bat will break, you'll hurt your hands, you'll strike out, you'll pop out, whatever. It's kind of like that, if I can help you visualize it. You're going to get survivors who because of their personality, how they handle stress and stuff, they're just inclined to give up, to just give away the farm. Like, here, yeah, you know what, I know he had $3 million in the 401k, but, you know, it's his name on the account, so what can I do? He might as well keep it. $3 million, okay. Or it'll be the house. You know, it'll be a marital home, that, or maybe it's a house that he purchased before they got married, but the marital community has been making mortgage payments for the last 13 years. A lot of domestic violence survivors don't realize that all those paychecks he collected while they were married are marital paychecks. Even though the name on the check still shows as his, the employer doesn't care. As far as they're concerned, he's still their employee, but the family court cares a great deal. And a lot of survivors don't realize that if, you know, for example, if his paycheck during the marriage helped pay off the mortgage for a house that he bought when he was a single man, yeah, the house is still his, but she's going to be entitled to a check for reimbursement, for improvements in the value of the home during the time span that they were married, because her labor and sweat as a member of the marital community, him and her as a community, helped improve the value of that home or helped keep the note down. And so you'll see a lot of survivors who will just throw away that stuff, or they'll give up on decision making and parenting time because they just don't want to fight. They want peace. It's just not in their nature to be confrontational. So they have the right to do those things, but on the other extreme, you'll have a woman who's maybe been told for the last 15 years that she has no voice whatsoever, no right to talk, and she's had it. And she's just going to talk, and you're just going to have to listen to her, and judge, you're going to have to listen to me too, because I'm tired of giving in, and this is what I want. And the danger with that approach, it's marvelously empowering at first to her, but what happens is that's the reaction where she fights everything, even stuff that really shouldn't be fought. Classic example, if there's an argument about where the child exchange should it be at McDonald's? And she's like, no way, man, it's got to be Burger King because that's 2 blocks closer to my house. Or they'll argue about, you know, should the child exchange time be at 6 o'clock? And she's like, no way, 5:55. That's when I'm free. That's when I'm going over. I'm tired of him running my life. It's going to be 5:55, not 6 o'clock. Now, to the average person looking in on that case, they're going to think, for heaven's sake, what is her problem? Is she really going to go to court and fight over 5 minutes? Is she really going to fight over McDonald's versus Burger King? Because, you know, they're both going to kill you, right? But to her, she is standing up for herself for the first time in years. So it is a big deal. So what you have to do with these two extremes is you have to help the pacifist, if you will, understand, yes, you can still be non-confrontational while still sticking up for yourself. And if there are a list of 10 things that you really ought to be fighting for, and if you really don't want to do it, then let's at least pick out these 2 or 3 that are really big deals, because I think, you know, Jill, when you look back 10 years from now, you're going to really wish that maybe you had stood your ground on this. So maybe you try to help nudge the pacifist a little bit towards sticking up for herself more. And if you're dealing with someone who's just become hyper-aggressive because this is her way of addressing this, of healing, then you sit down and say, okay, here are 10 things that he's saying he wants. Let's pick out the 2 or 3 things that are really kind of important and not fight over these other things, so that you can show the judge that you're capable of nuance, that you're capable of picking the right hills, you know, to fight over, and not sweating the small stuff. So that's going to be an important challenge, but a very valuable one if you can help them get to that middle ground. I'm going to skip, because we're about 5 minutes away from, let's skip that. If you want to have coffee with me sometime, I can tell you all about how the system's kind of messed up between juvenile and family court. A lot of work to be done on that issue. There's the issue of batterer behavior. You know, these next couple of slides, yeah, they deflect and minimize, and they will do that. The best way to look at an abuser's response in family court, consider it like a bunch of fallback positions. They're really good at this. You know, they'll start with, hey, nothing happened, up here in the upper right-hand corner of the slide. She's lying. There was no incident. She's making it all up. But let's say she's got evidence that it did happen, that something happened. Well, then his next response is going to be, well, maybe there was an argument, but I didn't do it. I didn't cause any damage. I don't know where that hole in the wall came from. That must have been her with her drunk friends. I would never do that. And then let's say that she's got a recording of him telling her over the phone, yeah, I hit the wall because, you're a lying bitch and I know you're cheating on me and I had to make a point. Well, now he can't really say he didn't do it because she's got a recording. So his next response is going to be, well, I may have hit that hole in the wall, but she started it. She provoked me. She does this to me all the time. She gets under my skin. And so, yeah, I'm not proud of the fact I hit a wall, but, Your Honor, she's just as bad as I am. And, we both have our failings. All people are human, blah, 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 blah. And it's a masterful presentation because the judges want to believe that both sides are relatively the same, that no one of them has a monopoly on wholesomeness or purity. And so judges by their nature want to appear even-handed. So that strategy from a batterer is gold in family court because it doesn't even require him to admit that he's a rotten person. All he has to do is convince the judge that he's no worse than she is. So that's why you'll get that argument. And then even if she can prove that actually, no, he was the instigator and he was the predominant aggressor, then the inevitable fallback response is, well, yeah, I did hit her, I slapped her, but, it's the only time it's ever happened. It was that one time, and it was 1.5 years ago, and I've made amends. I got my diversion. I got my certificate with the fancy red bow and the golden seal, and I love my kids, and I want to be a dad. And that kind of goes to the last argument, which is even if it happened more than once, Your Honor, I'm still a good dad. I can still be a good dad even though I don't get along with the mother of the children. And this is another big, big problem in family court is this is a really popular argument. It's actually kind of offensive. How many people, behavioral health professionals, court appointees like custody evaluators, the judges themselves, attorneys, everyone seems to have this insane idea that you can beat the heck out of your wife or the mother of your children, demean her, degrade her, rape her, burn her, isolate her, confine her, ruin her life, if somehow you can still be a stand-up guy and be a good dad, even though you did all these things to the mother of that child. You could probably sit down at a Denny's somewhere and take a poll of 5 strangers, do you think this is someone who should have access to children? And I bet 3 of them would say no. And yet you walk into family court and it's almost gospel that come heck or high water, we need to do some of that equal parenting time because the kid's got to have both parents. So this whole fallback argument that batterers do, it's pernicious. It infects the entire system, and it plays into all of the inclinations and fashionable arguments that are going on right now in family court. So you got to be ready for that too. I threw this batterer bingo chart out here. I'll give you the 30-second explanation. I was preparing for a presentation about 7-8 years ago, and while I was doing it, a lawyer for an abuser called me, and he wants to find out why we were being so difficult on this case. And he started basically fumbling out a litany of all the different excuses that batterers offer to excuse their behavior. And as I'm on the phone, I'm thinking to myself, my God, if I was playing bingo and all these excuses were on a chart, I would have so totally won about $5,000 by now because I'd have bingo all over the board. And I thought, oh, I know, I'll make a batterer bingo chart. So you are now the proud recipients of the batterer bingo chart. I will give you in the written material responses to all these excuses that you can help educate your clients with. But I just wanted you to have a visual of some of the more common excuses that you'll hear abusers offer in family court. It'll help your client prepare for them. Going to skip this one. This has to do with, a lot of people say, oh, domestic violence goes both ways. It's not just the men hitting the women. The argument is partly true and a great deal false, but it bears a more complicated explanation. That'll have to wait for our copy too. That's a lot of coffee we're going to be drinking, but that's okay. Coffee's good for you. That has to do with the same issue, so I'll skip that now. Here is the statute, the new law that went into effect on January 1st of 2013, so not so new anymore, but you'll hear people still refer to as the new custody law. And this is what the law actually says. I'm not going to read it because you're all capable of reading, but you will notice that nowhere in there does it say anything about equal time. Nowhere in there does it say anything about 50-50. You don't even see the numbers 50-50 in the statute. And yet you will hear people describe Arizona law as being a 50-50 law, and it's not true. What happens, though, is, okay, you see that language there? This is how people tend to read it. They emphasize the stuff that they want to hear. So this is the part that the 50-50 folks love. The court shall adopt a parenting plan that provides for both the parents to share decision-making regarding their child and that maximizes parenting time. When really, this was put in as a protective measure. And this came out of that work group that I was on. And we put that language in there as kind of a last-ditch way of protecting kids who came from homes where there was substance abuse, mental illness, or family violence going on, because it kind of guards against this idea that every family is the same, that they're widgets, interchangeable, and that people don't have their own individual unique needs, which, again, was really offensive, that everyone just seemed to love this idea that one size fits all. So when your client is doing litigation and you hear the opponent or even the judge start talking about, hey, I'm a 50-50 judge, or hey, it's all about 50-50, make sure to keep drumming home this point that this introductory clause, it was put there for a reason, which is that the parenting plan still has to be consistent with the child's best interest. And if maximized time or 50-50 time is not consistent with the kid's best interest, then Arizona law does not require equal time. And you have to be willing to stick to that and make that point without overdoing it, without overstating your case. Gonna skip over this. This slide, I'll have to simply stick with this. Whenever you possibly humanly can, get a hold of counseling records that an abuser has ever produced or gotten into, whether it's marital counseling, individual counseling, or if you went into court order counseling because of a criminal case, you're going to want those records, because it's the only way you're going to be able to show just how much he actually learned. Did he even really participate in the counseling? And if he did, what kinds of things was he saying? Anyone can produce a certificate at the end that says, congratulations, you're a new boy. But a lot of times I'll take that certificate and I'll start asking questions of the abuser about what he learned from that counseling, and they start coughing up all the same excuses they made before. And it can be really enlightening. So I'm going to skip over. Yeah, we're almost out of time. I want to mention some of these new cases, maybe 30 seconds each. There's a case called Murray versus Murray. And it came out last year. And the citation will be in your materials when we send it out. But it's a 2016 decision. And the Court of Appeals basically warned folks that even emails can be construed as a binding agreement if, when you read them together, it's clear that the parties reached an agreement, an understanding. So I know in this day and age, people fire from the hip. We have a man in the White House who fires from the hip. And texts and emails and all these things, people speak rashly and they throw things out there. And your client may not realize that she may be walking herself into a binding agreement because she tries to placate him over email just to kind of make him go away. And she may not realize that she may be tying her hands into a settlement that no lawyer could ever get her out of. So my advice is, if you're helping someone who's a DV survivor, chances are the other side is not someone who has her best interest in mind, and she needs to be really, really careful about what she agrees to or even implies that she would agree to when she does text message and email, because it may come back to haunt her. And then Ditto here. There's a case called Richardson. It's unpublished, so lawyers will know that you have to be careful how you cite this. But this is kind of a case that cut against the other one, where the father tried to claim that there were text messages that established that they agreed that there would be no child support paid. And the Court of Appeals in this case rejected that argument, and they did it for a couple of reasons. First of all, the text messages weren't entirely clear that the agreement had been reached and approved by the court. And that got to issue number 2, which is child support's not something that the parties can bargain away. A child has an independent right under federal law to be supported by both parents. And that's going to kind of get me to my last point, because this is a really common pitfall that I see a lot of women make, domestic violence survivors who are putting their kids first. I'll have a lot of clients who will say, Tom, let's just offer him no child support. He doesn't have to pay any child support or spousal maintenance if he'll just go away, leave me alone, let me raise the kids. And I get why she's saying that, because from her perspective, he's never put the kids first. He's been violent, abusive. He's even hurt the children, shown no interest in them whatsoever. So from her perspective, it makes perfect sense. Why not make that argument? The problem is you have to remember domestic abusers are all about image. They want to look good. They will never admit publicly that they could be bought off from being a father. They want the world to think that they are caring, loving, doting dads who yearn to breathe the same air as their children, and how dare this woman try to take away my equal rights as a father. Well, what do you suppose is going to happen, and what do you suppose he's going to say to a judge if she sends out an email saying, hey, if you give up the kids, you don't have to pay child support, right? Okay? He's going to come into court and he's going to say, see, Your Honor, she doesn't respect me. She thought that I'd be willing to sell my kids for money. Well, Your Honor, it's disrespectful. This is why I can't co-parent with her, because she's never treated me like an equal. You get the whole thing here. He's taking all the behaviors that he does and projecting them onto her to make her look like she's the unreasonable one and she's the one who has no respect for him. Batterers love doing that. So that is an argument that she cannot make. She cannot make that offer to him. If he's stupid enough to send that to her first, if he proposes, tell you what, you can have the kids, just don't gouge me for child support, then okay, that's a different issue, because he's the one who committed in writing to that argument first. And then if he tries to come back later and say that she's the one, she can say, hey, Your Honor, I didn't know he was going to go there, but here it is. Here's his email. I was just answering him. But unless you got that overture from him where he sets that tone, you cannot make that argument, even if it makes sense based on the conduct of the parents during the marriage. She will not get away with that in court, and she'll look really bad. So don't let her do that, or she'll regret it. Okay, and here it is. It's 11 o'clock, and I promised I would be there. So here I am, looking at questions. Looks like Michelle had a question regarding impossible choice number 2, alerting a victim to possible criticism. My concern are decisions and actions taken against the victim that accompany those criticisms. Well, I mean, yeah, that stuff does happen. Sure, that's what makes those choices so awful. Is that no matter which way you go, there's going to be a consequence that she did not deserve. You know, if she stays in the relationship, the consequences are obvious. That's the reason you were involved in the first place. If she takes off with the kids, yeah, they will, you know, an energetic abuser who's got lots of money will probably, you know, accuse her of kidnapping. So yeah, I mean, there are consequences for all three. The reason I mentioned those slides to you wasn't so that you just give up and say, what's the point? I wanted you to be aware that there are other folks who don't even consider that, people who are critical of survivors, who don't even contemplate that those are the three horrible choices she's got. In the end, if she's going to make a domestic violence allegation, she's got to do the best she can. And I know perfectly well there are going to be cases where she doesn't have a lot of evidence, but you still tell the truth. And if the judge chooses not to believe you, then you can't do much about that. But there's a difference between a false allegation and an unsubstantiated allegation. One of those false allegations will get you in a hot water with the court if the judge believes you're lying. But if it's just a question of, hey, this is what happened, and I know I don't have a lot, but this is what happened, 1, 2, 3, 4, 5, the judge may still not side with you, but there isn't that element of suspected perjury. And your client's going to want to be able to tell her kids someday that she told the truth. I don't know if I answered that question, but I think I did. Okay, and then Carmen had a question. I'm a new advocate. I keep hearing the equal parenting time thing and how the kids need a dad, but what about the argument that the kids don't want to see a dad? Yeah, I got a case going on right now where DC has substantiated abuse, physical abuse by the father against the child, an 11-year-old boy, and the boy does not want to see his dad. And the court is still proceeding with a reunification plan, and people are really starting to lean on my client, the mother, for being an alienator because she's not waving dad's flag and cheering him on and trying to get the kid to go over there. It's a horribly complex case. It's one of the most fiercely contested I've been in a long time. And about the best answer I can give you, and you're not going to like it, but it's an honest answer, is that sometimes there is no good response. Consider it this way. You can't let an 11-year-old child run the family court. Technically, you can't even let a 17-year-old run the family court. They're not going to do that. And it's not hard to imagine why. I know there's some states, I've heard that New Mexico and Texas do this, where if you reach a certain age, the child's wishes become presumptive, and unless you can overcome that presumption with evidence of your own, that the court's supposed to follow the kid's wishes. I think those are terrible laws. And I know it sounds counterintuitive as an advocate against family violence, but the reason why is because the minute you put the kids in the driver's seat, every parent in the world is going to start bribing and blackmailing that kid to see things their way. Hey kid, little Johnny, we got a hearing next week, and you love your dad, and oh, by the way, here's a new iPod. Oh yeah, well, don't you love your mom? Here's an iPhone. Look at that, an iPhone. And then dad's like, well, look at this. I just bought you a new motorcycle. Or there's threatening or guilt. And it's a horrible position to put the kids in. And because we don't put the kids in the driver's seat, the flip side of that is that we don't necessarily deny parenting time just because the child says, I don't want to go over there. Now, the reality is the older the child gets, the more that wish starts to hit harder. It's very difficult to get a 16 or 17-year-old to go anywhere that a 16 or 17-year-old doesn't want to go. Good luck with that. Most kids that age will vote with their feet, go to stay at a friend's house, or they'll get themselves so involved in activities after school that parenting time is almost meaningless because the kid's deciding for himself, this is what I'm going to do. And, of course, the other danger is if a parent puts their foot down too much with a 16 or 17-year-old, they'll pay the price when that kid's 18 because that kid will want nothing to do with that parent moving forward as an adult. So I guess my answer is if the child's really young, you have to take into account that the kid's young and might not understand the complexities of what's going on. Children who are preteens but old enough where their views are more mature, more complex, they're more capable of evaluating competing interests and all that. They'll interview children and they'll try to get their wishes. But this is a really dangerous area of family law because a lot of victims will talk to their kids and say, hey, you remember that time that dad hit me? If you're interviewed, don't forget to tell them about that time that dad took a wooden board and hit me between the eyes. And from the mom's perspective, she's like, what's the problem? I didn't tell the kids to lie. I told them to tell the truth. And the kid just goes in and says, well, I don't want to be with dad. And mom told me to make sure that that he hit me, that he hit her in the face with a board. Well, that's going to come off as coaching. And so the question that was just asked by Carmen actually raises two different issues. And the first is, do we defer to the children in general? And the answer is no, we can't. Even though in a given specific case, the kid's wishes really ought to get some weight, we can't have a policy where kids get to run the show that way because it'll be a runaway freight train. And connected to that issue is the problem of parents who lobby their kids to look a certain way at the relationship in the hope that the kid will then report to the judge or report to the evaluator that that's what's going on in the home. And the judge cannot assume that your client is the one telling the truth. Your client may know that it's the truth. You may know that it's the truth. So may I. But we're advocates. We're advocating for one side of the case. The judge doesn't have that luxury. So kind of my long-winded answer to that question. I guess it was just those two questions. So here we go. Someone asked something else. Wouldn't that be an appropriate time for BIA? It could be. For those who don't know, a BIA is a best interest attorney. It's a third-party neutral lawyer who's brought into a family court case to, as much as possible, present an objective view. I've had mixed success with BIAs. As with all people involved in the court system, there are good lawyers and bad lawyers, good judges and bad judges. There are good evaluators and bad ones, and there are BIAs who are super conscientious, super smart, and there are ones who just don't get it. They don't understand it. They wanted to volunteer and get involved because they wanted to do the right thing and be helpful, but they don't have the experience and skill to recognize some of the complexities of domestic violence. So you have to be careful. Really, you have to be careful when you're asking the court to appoint any of these people, whether it's a best interest lawyer, a court-appointed advisor who would interview the children and file a report, or even something as expensive and in-depth as a focus assessment or a comprehensive family evaluation. These are all pot luck. You get luck of the draw. There's some of them who do a really good job, and some who just will not only not help you, but their contribution may actually make things worse. Because, best interest attorneys, they may be technically neutral, but they're human too. And they will at some point start to make a decision about who they believe and who they don't believe. And, read an article sometimes about the dangers of confirmation bias. They talk about that with the police, but it also applies with equal force in family court. Once a police officer's decided that he knows who's guilty and who's not, it makes it really easy to start picking out the evidence that supports your view and discarding everything that might contradict it. Well, no point in just picking on the police. That's true of all of us. Therapists do it, lawyers do it. Once we make up our mind who's being honest, you have to keep reminding yourself, okay, I'm supposed to be an open vessel here. I'm supposed to keep processing information whether I like it or not. That's hard to do. Human nature fights against that. So be careful with BIAs. They can be wonderful, but they can also be a disaster. That probably wasn't a really helpful answer. Sorry, but it's the truth. Okay, I don't see any more questions, and it doesn't look like anyone's typing, so I'm going to close this out. It was a real privilege. Thank you. It's kind of weird talking into the phone and hearing absolutely nothing back from anyone. I think if the neighbors heard this, they might be concerned for me. But it was a real pleasure, and my contact information is right here. Those are my grandkids on the left, and my daughter and our irritable cat on the right. But the important information is there. That's my new contact information. If you've met me before, especially like last year or the year before, throw away all my old contact information. It's not any good anymore. I moved to a new office in the West Valley in April. So you're going to want to keep this stuff here. Okay?
Hey, thank you so much, Tom.
Sure.
We really appreciate you presenting for us. And for everybody in the presentation, we'll send out the recording link and the presentation and Tom's contact information and everything sometime next week.
Awesome. Well, thanks, Ginger. Everyone have a great weekend, and chin up. Hang in there and keep doing all the good work.
Thanks so much, Tom.
You're welcome.